welcome and good morning to everybody. It's always difficult to wake up so early, but we are very happy. We see there is a lot of interest. Having an early debate in the morning is not probably the best things we can have it, but I'm sure that the distinguished experts and speakers we have on the table, they will make sure that they will provide you food for thoughts, basically. And let me start by introducing myself, then I will introduce the speakers, and then I will explain a little bit what we want to do during this session. Myself, I'm Cosimo Monda. I'm the director of the Center on Privacy and Cybersecurity at University of Maastricht in Netherlands. Now, I will introduce very shortly, very briefly the speakers. Perhaps they can add some additional information about themselves before they start speaking. I'm happy to have on my right, the first speaker is Anna Bukta. She's the head of the unit policy and consultation at European Data Protection Supervisor. I'm sorry, Anna, she was not listed in the speakers, but she's very welcome on board, because one of the panelists, unfortunately, was not able to make it, Herke Kranenborg, who is also fellow at our center in Maastricht. The second speaker, actually, the deus ex machina of this panel, let me say, because she's an expert on AI, is Maja Brkan. Maja, she's associate professor at Maastricht University. She really work a lot on AI and the impact of the AI on the fundamental rights and fundamental interest of the individual. She's also, Maja, the academic director of our new master on privacy, cybersecurity, data management, and leadership. It's a very long title, but it's an excellent master, I do believe. The other speaker, which I had the pleasure to somehow we were together in a conference in Vilnius. I was very impressed about her knowledge and capability. This is Eva Lievens. She's an assistant professor at University of Ghent, I think. Yes, Ghent. She specializes on children right, basically. She's probably the core activities in her research field. And then I'm also happy to have also the industry on this panel. I'm happy to have on board Daniel Schönberger. I think I pronounced well your name. I really exercised yesterday, because when we are Italian, we have some difficulty with a name which doesn't have the same sound. He is the head of legal of Austria and Switzerland at Google. Now, after this short introduction, please, if you want to say something about yourself, you can say when you start talking. The rules, we want to make sure that there is enough space for discussion. This is why we have agreed with the speakers to limit their intervention to not more than 15 minutes at maximum, in order to leave at least 20, 30 minutes for questions from the audience, because it's always interesting to also see what you think from the other side. I have to say, the setting of this room is peculiar, because I do not see you. I hope you see us, because the light is really in front of me. Now, what we will discuss during this panel, we will have a discussion about what are the impact of technology. Artificial intelligence, technology, for sure, they make our life probably easy. They bring major societal benefit. But the question is, there is any cost about people's fundamental rights and core values such as, for example, free election, democracy, consequently? This is what we try to discuss today. I think we will have a discussion about 4 fundamental questions during this panel. We will look at Maja, she will discuss probably more in detail what is the impact of AI on free election, following also the case of Cambridge Analytica. Eva, she will focus more on the children's rights. What is the impact on AI on children's rights? We will also discuss a little bit of the latest case law from the Court of Justice to see how we can solve the tension between AI and impact, digitalization impact on people's fundamental rights. And also, having on board the representative for the industry from Google, we will also see how we can develop, we can deploy new technology, take into account the fundamental rights and interest of the people. This is the subject. I think it's enough. I will ask now Anna to start. She's coming probably from an authority, European Data Protection Supervisor. She can bring in some input regarding what the DPS, for example, is working on it regarding these items. Anna, the floor is yours.
Thank you. Thank you, Cosimo. Thank you, Maja, colleagues, for having me on this panel. My apologies to all those who came here specially to listen to Herke Kranenborg. Obviously, you know, you're free to leave the room now. No offense.
No.
We've talked a bit how to best approach such a vast theme as impact of AI and more broadly digital technologies on fundamental rights, and we agreed that I will try to give a broader overview of how in the past years at the EDPs we have looked at these things, and also what trends we see and what issues we plan to work on in the coming years. And I apologize, but really it's very difficult to keep eye contact under these circumstances, so forgive me, because it's really the lights are very, very, very bright. I will do my best, though. So, for those who are not very familiar with what we do at the EDPs, in addition to enforcing the EU bubble equivalent of the GDPR in relation to data processing by EU institutions and bodies, by the Commission, the Council, the Parliament, other bodies and agencies, we also provide advice on legislative proposals, on policy initiatives with impact on personal data and privacy. And we also, on occasion, intervene before the Court of Justice, either on our own initiative and direct actions, infringement proceedings, and sometimes we are invited by the court to answer questions or to come to hearings in certain cases. And in this latter capacity, I had the pleasure to take part in some of the cases ranging from DRI, Canada, PNR, Schrems, and most recently a number of cases related to data retention. So I also take a keen interest, obviously, professionally and personally, in how the court approaches the issue of technology and fundamental rights. But I will come to that a little bit later. To begin with, regarding the EDPS advisory role, and more broadly the advisory role of data protection authorities, which they all play in their respective countries, we have started collectively looking into AI, digitalization as such, big data many years ago, AI also slightly before it became the hype that it is today. We have, as EDPs, prepared a background paper back in 2016 for the International Conference of Data Protection Commissioners, that is now, I believe, called GPA, Global Privacy Assembly. In any event, since then, our line or our approach, our basic approach has not changed, and that is to say that, in fact, data protection authorities are quite well placed to assess both, or to discuss, to engage on both the opportunities presented by new and emerging technologies, but also on the risk related to personal data protection, to privacy, and to other fundamental rights. Why? Because it is in our DNA. So this is what DPAs have been doing for many years, thinking about impacts of data processing on individuals and on societies. So this is not to play the Cassandras, not to discourage people from take-up of technology, but we plead for a realistic assessment and indeed for early engagement to be able to understand and to anticipate and to work together with other stakeholders in order to make deployment of technology beneficial to all in society. So as an example of the issues that we have looked in the past years, and you will find many documents on our website. I mean, since years, obviously we've been looking at the use of various IT tools and setup of IT systems at EU level. And you should not be mistaken, this is not just about some little databases that the Commission might have to handle salaries data of officials, but this also covers those large-scale systems that are set up at EU level to process information, including biometrics of refugees, migrants, border crossing, Schengen, visa, etc., etc. So this is a large variety of technologies that have been deployed in sometimes particularly sensitive fields, impacting minorities, impacting third country nationals, impacting migrants, refugees, children. And so this is also quite a vast area of our work. More recently, closely linked to that, we have been looking into the interoperability question. So first, proposals from the Commission, which by now have become law, and which consist in, if not interlinking all those databases, at least in providing possibility for authorities, including law enforcement authorities, to easily consult all of those databases and to identify matches, those individuals who are listed in more than one database. So here we also have long discussions about the impact of such an approach on the basic underpinnings of data protection law, such as purpose limitation, for example, but also more broadly the question of to what extent this kind of legislative approach can be justified as being necessary and proportionate. And that brings me to my second point. So in addition to analyzing proposal by proposal, system by system, technology by technology, as the Commission or the other legislators call on us to do, we also try to provide, let's say, more systematic or theoretical framework of analysis of these questions to the other institutions. And to do that, we analyze first and foremost the applicable legislation, literature on the Charter of Fundamental Rights, and obviously also case law of the Court of Justice. And with that, we aim to also provide more practical tools to policymakers how to think about the issue of impact on fundamental rights and ensuring necessity and proportionality in this context. And this is just to say that over the past couple of years we have published two documents. One is called, we call it the Necessity Toolkit. So it's again, provides a theoretical, systematic framework plus some practical advice how to assess necessity of limitations to be imposed on fundamental rights pursuant to the Charter. And more recently, we also supplemented this necessity toolkit by guidelines on proportionality. So again, this is partly compilation of relevant case law and literature, and partly several clearly described steps, analytical steps that we would advise need to be taken to assess when assessing impact of legislation, mainly in this case on fundamental rights. Now, finally, this analysis is currently mainly focused, not to say limited, but clearly focused on the fundamental rights to the protection of personal data and privacy, so Articles 7 and 8 of the Charter. But in recent years, it has become very, very obvious that there are very strong links, obviously, between the right to data protection and not only the right to privacy, but also the right to freedom of expression, association, the right to judicial remedy that has come out very, very clearly also in the Court of Justice case law, such as Schrems, for instance, in relation to safe harbor. There are also obviously links to the broader questions of non-discrimination or prohibition on discrimination, and this has also come out very, very clearly for us in relation to this interoperability scheme, and also new systems such as the entry-exit system or ECRIS TCN, which is a large database for storing and exchanging transnationally criminal records of third country nationals as well as dual nationals, so those EU citizens who also happen to have a nationality of a third country. In terms of diverse impact of this legislation potentially on different communities, this discrimination aspect came out very strongly. And recently we have also seen in a recent Advocate General opinion on the Hungarian case about freedom of association, that there are very explicit and strong links were made to the right to data protection and data protection legislation. So this all leads to us to a clear, irrefutable conclusion, I believe, that data protection, privacy are all very strongly interlinked with human dignity and the other fundamental rights in the Charter, and that they are also very important underpinnings of democracy, actually, and strong links with the rule of law. And it is this last dimension of the broader connection between data protection and privacy and rule of law and other fundamental rights that we intend to explore and work on in the coming years at the EDPs. Thank you very much.
Thank you, Anna. Thank you. You were very in time. I think this is actually a big, what Anna, she pointed out, this interrelation between the Article 7 and the Article 8 of the fundamental, it's really the core element. Because both fundamental rights, data protection and privacy, at the end of, despite the fact that they have a different definition, different aspect coverage, but both of them, they lead to cover one particular aspect, the individual autonomy of the individual and the fairness. That means individual autonomy, what I see myself, what I'm always say, it's just the fundamental rights of any individual to explore their own mind in a space, by interaction with the other, in a space which is safe. And this is the question. When we talk about fairness, what we are talking about, basically let the people to take control of the data related to them. And this is one of the big issues which we need to discuss, particularly when we are in the area like vulnerability. And now it's just the point where Eva, she can enter into the discussion to illustrate there are situations where vulnerability is also playing an important role. We should not forget these big elements. Eva.
Thank you very much, Cosimo. I'm very happy to be here, to be part of this panel. And actually, I think that my story links up very well with especially the last part of Anna's presentation just now. I think it's very, very clear, and we cannot deny that technology and artificial intelligence as well is present in children's lives. I would argue for better, but maybe also for worse. Many children currently grow up in environments where some of their conversations might be picked up either by smart assistants who also help them or who also read them stories, or by connected toys. with which they interact. When they use online services, they are offered advertising, targeted advertising based on their interests and their likes. Not only private companies interact with children, but also in more public spaces, such as schools. Increasingly, AI is used, for instance, by deploying facial recognition to check students' attendance. Both the Swedish and the French DPA have issued decisions on this in recent months. But of course also adaptive learning trajectories that might individualize learning to the benefit of children. They also are confronted with things like deepfakes, either on social networks on which they are active. But for instance, a very recent example, last week I saw on Flemish television a deepfake video of Greta Thunberg that was actually used as an advertisement for a program by a broadcaster. So it's really something that children are confronted with on a daily basis. Of course, this often benefits them significantly. So the for better element is definitely there. Some of these technologies can enhance social skills, for instance, also with respect to children who have disabilities. Engaging with certain technologies, certain robots might actually improve interactive skills. The learning trajectories that are adapted, that I mentioned before, can be really beneficial for students to make sure that either they have more challenges or that they are helped more than other students with respect to things that they have difficulties with. Prediction of diseases can, of course, improve their well-being to a large extent. And another aspect that could relate to their right to protection is the fact that AI can be used to automate detection of child sexual abuse imagery. So many good causes that the technology might help. But of course, we also are quite concerned about the fact that these technologies use mass amounts of data of children from birth onwards, even sometimes before birth, because people often are so proud to be pregnant that they put ultrasounds on social networks, which is of course understandable to a certain extent. I think yesterday there was also a panel on emotional detection. With respect to children, especially if the technology is present in very intimate spaces, in living rooms, sometimes even in bedrooms, in bathrooms. Very intimate details might also be shared involuntarily. I think that at this moment in time, it is really hard to assess and predict the exact impact that growing up in an AI-influenced environment will have on children's lives in the long term. For that, we would need to have longitudinal data, and of course, we are still in the take-up of the technology. So it's really hard to assess how children that grow up today will be impacted by this technology in the future. And I think that aside from a potential direct impact on the right to privacy and data protection, which is more or less the forum here in which we always think about this right first, I think there might also be either direct or also collateral impacts on a range of other children's rights. And there I want to echo what Anna has said. It's not only about the right to data protection and privacy, it's also about the impact on the right to non-discrimination, which is really something that it's not even just a right for children, it's also one of the 4 fundamental principles of the United Nations Convention on the Rights of the Child. There might be an impact on their right to education, especially with the increasing uptake of AI technology there. There might be an impact on the right to protection from commercial exploitation. There is a specific right in the United Nations Convention. Usually this right is mostly interpreted with regard to child labor, but increasingly there are arguments that put forward the fact that the right to protection from commercial exploitation is becoming increasingly important in a very commercial environment in which children grow up. And then, of course, especially with regard to manipulative purposes. There are, of course, also purposes that are acceptable. And then I think what is maybe one of the most important impacts is the impact on the right to freedom of thought and the right to freedom of expression, information, which is crucial to form opinions as well. And here I would like to refer to a recommendation or a declaration from the Committee of Ministers of the Council of Europe. It's a declaration from 2019 in which they state that the current levels of fine-grained algorithmic persuasion that individuals, not children per se, but individuals in general, are confronted with, that this may have significant effects on the cognitive autonomy of individuals and their right to form opinions and take independent decisions. And this makes me think a little bit about what Cosimo was saying. The right to autonomy, to form your own mind in free spaces. And the Committee of the Council of Europe, they acknowledge that these effects are currently underexplored, which I think is true. It's also very difficult to research, but cannot be underestimated. And I think this is especially true with respect to children. If you think about childhood and the way in which these capacities to form opinions are really evolving at full speed during childhood, that this is something that we need to take into account. So, setting the scene, what do policymakers say about these issues currently? As you all know, and I think this is also reflected in the fact that there are so many panels here at this conference on AI and policy. Many policymakers at different levels are thinking very hard about AI and how to regulate or how to approach it. Council of Europe, I think there's a session this afternoon, especially on this topic, European Union, with a high-level expert group on AI. Many things are happening, but actually, if you study the documents that are available, very little is said about children specifically. In the ethics guidelines of the expert group, there is some reference, being mostly that there needs to be particular attention to situations involving more vulnerable groups, such as children, but this kind of goes without saying. There's a little bit more detail in the policy and investment recommendations for trustworthy AI, where there is a recommendation to establish a European strategy for better and safer AI for children. So this sounds promising. And this also especially refers to the fact that children should be able to grow up in free and unmonitored spaces. It's a high ambition, free and unmonitored spaces. For their development. There's also some references to skills and education, making sure that children have skills to deal with AI. There's also a mention of establishing a legal age at which children receive a clean data slate of any public or private storage of data related to them as children. I think it depends a little bit on how this is conceptualized, whether it is a good idea or not. Wiping out as a standard the history of a child, I also think it's not something that we really want for everyone in any case. So what do I want to argue for at this specific moment in time? I think, as I mentioned before, that at this moment in time it is hard. It's hard to show that the practices that I mentioned, some of the practices lead to actual harm on the well-being of children. And this, of course, makes it hard to advocate for stricter regulation or prohibitions on the deployment of certain technologies, because regulation, it imposes restrictions on certain behaviors, on certain acts, and hence there should be a compelling reason to regulate. But with respect to certain issues, and I think this really is valid with respect to the well-being of children, I would like to remind us about the precautionary principle. The precautionary principle, it's a principle that finds its origins in environmental policy. It's a principle that suggests a better safe than sorry approach. It's a principle that compels a society to act cautiously if there are certain, but not necessarily absolute indications, scientific indications of a potential danger, and if not acting, these indications could inflict harm. And so this precautionary principle is something that we should take into account. It is also mentioned in the Council of Europe's recommendation on guidelines to respect, protect, and fulfill the rights of the child in the digital environment. I hope that all of you know about this recommendation, because it's very comprehensive and deals with a lot of important elements. But this precautionary principle is also included in this recommendation. Secondly, and then I'm going back a little bit to the right to data protection and privacy in particular. I think that current legal frameworks that are relevant to the practices that are here under discussion, they often use or prescribe empowerment measures as a means of protection. So we want to empower children, we are going to give them information, we are going to give them rights to make sure that they can control the data that is used about them in these technologies. But I think that certain of these practices are so opaque and so difficult to understand for us as adults, let alone for children, that being informed or having rights doesn't necessarily amount to being protected when we are talking about children. I think the responsibility for understanding how data is processed and to assessing whether this is fair, whether you can exercise your rights, that this cannot be placed solely on the shoulders of children, and this also goes for parents. So de-responsibilization of children and parents, I think, is really important. This means, of course, responsibilization of other actors, data controllers, data protection authorities, policymakers, considering certain restrictions on processing of certain personal data, using child rights impact assessments that assess the full range of children's rights with regard to certain practices and not only focusing on the right to data protection. So just as a final conclusion, what do we have to look forward to? There are quite some things moving with respect to this topic. And we have the United Nations Committee on the Rights of the Child, who is preparing a general comment on the rights of the child in the digital environment. AI will be part of that, I think. The EDPB is preparing guidance specifically with respect to processing of children's data, so that's also something to look forward to. And with respect to this recommendation of the Council of Europe, there will also be an implementation handbook that will be published to give more guidance to policymakers and data controllers on how to deal with these issues. So lots to look forward to in the coming time. Thank you.
Thank you, Eva. Thank you, Eva. Let's move on because the time is running, and let's move to Maja to see what we can learn or what we can observe in this respect when it comes to election, for example. Yeah.
Okay. Thank you very much, Cosimo. So I will be focusing my presentation on the impact of data-driven political campaigns on EU fundamental rights. And as it has been mentioned several times already in this panel, the data-driven political campaigns equally, just as other policies or just as other practices based on AI, do not only impact data protection or privacy, but also other fundamental rights, such as freedom of expression, potentially also freedom of elections, and also the value of democracy. So I would like to start with an example. You are an audience which is probably aware that Twitter at the end of October has decided to ban all political advertisement, regardless of whether it is targeted or non-targeted. So So Jack Dorsey, the CEO of Twitter, announced at the end of October that they made a decision to stop all political advertising on Twitter because they believe that the political message should be earned and not bought. And this was followed by a similar move from Google, and I would be very interested to also hear some thoughts from Daniel on that. Google has decided to ban political advertisements as far as micro-targeting is concerned, meaning that a certain degree of targeting is still allowed, I think on the basis of a postal code or on the basis of gender, but not micro-targeting, for example, on the basis of psychological characteristics. And let's see now what Mark Zuckerberg had to say about a similar issue, whether they will prohibit the advertisement. So I would like to ask to start the video.
Could I run ads targeting Republicans in primaries saying that they voted for the Green New Deal?
Sorry, can you repeat that?
Would I be able to run advertisements on Facebook targeting Republicans in primaries saying that they voted for the Green New Deal? I mean, if you're not fact-checking political advertisements, I'm just trying to understand the bounds here. What's fair game?
I don't know the answer to that off the top of my head. I think
So
probably.
you don't know if I'll be able to do that.
I think probably.
Yeah, so as you
Do
can
you
see,
see a potential problem here?
as you can see, Mark, at that time when the hearing was taking place in the US Congress was not yet sure. Now he is a bit more sure. I have recently read in The Guardian that Facebook has decided explicitly not to ban political advertisements. So it seems that the entire primaries in the US are going to move from Twitter and perhaps also Google to Facebook, even more so than in the previous elections. So what I will be talking about today are three main points. I will try to be brief. Please stop me if I'm too long. First, I will talk very briefly about the characteristics of data-driven political campaigns. Secondly, I will talk a little bit about how these campaigns can impact data protection. And thirdly, I will talk a bit about how other fundamental rights can be impacted in case that there is a lawful use of data and there is no breach of data protection. So you are also a specific audience which is very specialized in this field, so I do not need to explain very much in detail how targeted advertisement works. In short, political targeted advertisement doesn't work any different than commercial targeted advertisement. Just the impacts are potentially broader because they impact the broader society and the outcome of elections, potentially, if that is the case. And obviously the reasons for using this type of advertisement is also quite appealing. You are able to send very personalized messages to people and make your campaign a little bit more strategic. And I think I also don't need to go specifically into the examples where these data-driven political campaigns have been used. They have been used in India, in Brazil, all over the world, and especially in Trump and Brexit campaign on the basis of this notorious quiz developed by Alexander Kogan called This Is Your Digital Life, which has pooled the data from millions of Facebook users and then profiled them. How is then the data protection impacted by these data-driven political campaigns? So one possibility is that actually we have at the same time as targeting also a breach of data. And here I would like to point out certain specific risks for fundamental rights. So one very obvious risk is the risk for fundamental rights for data protection and privacy, because a very big amount of data is collected and then people are profiled. So, you know, the entire system of Article 22 would be applicable here, potentially also all the rights from Article 22. I will not speak about it today because then the presentation would be too long, but I'm very happy to discuss this in the discussion. And then there are also other fundamental rights that could be impacted. One of them is freedom of information. In my view, these personalized messages quite clearly have a potential of limiting freedom of information of voters because they only get a certain segment of a political message of a political party. So A classical example is suppose that somebody is very much not caring about the environment, but is at the same time very scared of migration. Political party, which is very pro-environment and or very anti-migration, will then send messages to this person, which are only kind of raising or enhancing the fears of the person about migration. But they would not send to this person messages in favor of their political statements for the I don't know, in US Green New Deal, or now in the EU also the new environmental programs. So you see that you can get only a part of the entire political agenda of the political party, and this can limit your freedom of information. On the other hand, if you look to the whole system and to the whole data-driven political campaigns from the perspective of the political parties, who also have the right to expression, if we regulate somehow the fact that they can or cannot use this political targeting, then potentially their freedom of expression can be affected. So I will look a little bit into that later. And then there is also the question whether this targeting can actually affect the right to free elections. Intuitively, you could say, well, it can, but if you look specifically into the criteria that have been developed by the European Court of Human Rights in Strasbourg, the threshold for the actual impact of the right to free elections is very high. You really need to prove that a certain practice has twisted the outcome of the elections. And here I think we do not yet have an empirical proof that these targeted political advertisement actually twist the outcome of results. This is an assumption, but they can also have a lot of positive impacts. You know, perhaps they inform people better about political campaigns, etc. And there are also obviously potential risks for democracy, but here, for lawyers, I always say, well, democracy, I understand it here more as a value rather than the legal category from Article 2 of the treaties. You know, as we know from the case law on the rule of law of the Court of Justice, such as Commission versus Poland, etc., this Article 2 is not directly enforceable. So, you know, it would be difficult to claim that one of the treaty articles is breached in case of breach of democracy. Now, let's see how the policymakers have responded to the recent scandals of Cambridge Analytica. Just before the elections, which took place in May 2019, the regulation on rules of funding of political parties has been amended in order to state that whenever a political party or a political foundation takes advantage of an infringement of personal data, then this is something that should be prohibited. So here we are in the domain where they're actually breaching your data protection rules. So they would breach Article 22, or they would not have a consent, or they would illegally or unlawfully collect sensitive data, which we can very well imagine. Now, this regulation has a lot of advantages, obviously, but it also has some disadvantages, because I'm always asking the question, what about the data that has been collected completely lawfully? If somebody has consented clearly to a political advertisement, is this person protected or not? And here I would join what Eva has said, is that informing people is not enough. But very specifically, these new rules only focus on unlawfully processed data, so whenever data is processed not in accordance with the GDPR or the institutional regulation, etc. Now, for data protection lawyers among you, there is an interesting sort of procedural twist in those rules, and it is the relationship between the authority for political parties on one hand and the DPAs on the other hand. Usually when the authority of political parties takes a decision on whether there has been a breach of that amended regulation, there would be a decision of a DPA preceding that decision of the authority. So some authors claim, for example, Gabriela Zanfer-Fortuna was one of the first one who commented on that. She's claiming there is really a problem of fragmentation of enforcement, and that can very well be the case. On the other hand, you can also see it from the perspective that the DPA would kind of give a guiding light to the authorities. So we could perhaps even say the fact that the DPAs are involved actually unifies the enforcement a little bit more. But I have contacted also the Authority for European Political Parties, and they sent me a long email explaining the procedure, and in the end they said, well, we haven't had any cases like this yet, or they actually said we should check our website regularly. So for the moment, the fact that they haven't found any breaches during the European elections doesn't actually mean that there hasn't been any use of these data-driven political campaigns so far. But doctrinally, what I find quite interesting is that data protection seems to be acquiring a new level of protection. So traditionally, we always say, well, data protection has a twofold purpose. On one hand, it protects the fundamental rights to data protection, and on the other hand, it promotes the market harmonization. So we have a more private goal in the policy domain, and then we have a more public goal. But now it seems that sort of political regulation has been added to that. And data protection is quite an important element in the political arena. And if you have seen certain decisions from the UK Information Commissioner or the Italian Garante or the pending procedure in front of the Irish Information Commissioner, you can see that they have issued certain fines for Facebook in the aftermath of the Cambridge Analytica scandal. So, you know, suddenly, to me, this is really interesting that suddenly DPAs are being involved in something which is traditionally not actually their competence. Okay, and now to the last part of my presentation, to this question of what if somebody has consented to political micro-targeting, or if the data has been otherwise acquired lawfully. For example, somebody has made their political opinions explicitly known in a TV show or in a public, for example, in social media with settings where everybody can see it. What do we do then? Do we then say, well, this is okay, the person has consented, or do we still need to regulate political advertisement? And I think here we have some regulatory choices. If I start from the first one, the no regulation, this is currently not actually a regulatory choice because there is always a certain regulation that comes into place. So you would have a regulation on unfair commercial practices or an advertisement that would regulate this area, but we do not have specific regulation that actually regulates political micro-targeting, and it's questionable whether we really need specific regulation on that. I will go, when I go a bit further in that slide, also into that question. What we see currently is that there is a lot on self-regulation on that issue. Different social media have a different approach to this question. Okay, I will try to be brief. But I do not believe that either a self-regulation or the opting in or opting out by voters is sufficient. Just 2 points on this slide. The Commission is really trying to push for more transparency and labeling of these political advertisements, meaning that whenever a voter would see an advertisement, it would be clearly indicated that this is a targeted ad. I personally do not think that this is a sufficient measure because it could potentially not prevent a manipulation. And the European Parliament is actually proposing a ban of profiling for the purposes of political advertisement. And this is my last slide, where I analyze the pros and cons of such a ban of profiling for the purposes of political advertisement. I think that the positive side of such a regulation is that it would help protect, just 2 sentences, help protect freedom of information because it would sort of limit these personalized messages, and I think it would also be quite an effective regulatory approach. On the other hand, there could be a problem with the freedom of expression of political parties because they should be able to express their views freely, and the case law of the ECHR is not very clear on that. And there could potentially also be difficulties in enforcement because the entire issue would go into the question of what is targeted advertisement and what is not. If you allow me just one quote from...
Just one quote.
One quote from the chair of the US Federal Election Commission, she says, here's a move that would allow political ads while deterring disinformation campaigns, restoring transparency and protecting the robust marketplace of ideas, sell political ads, but stop the practice of micro-targeting those ads. And I'm personally more in favor of that position. Thank you very much.
Thank you very much, Maja. Now, Daniel, the floor is yours. Let's try to keep it really in 15 minutes because I would like to have time for discussion, okay?
Sure. Thanks so much, Cosimo. Good morning. Thanks for having me. If I may have the clicker here.
Yeah, sure.
So I got slides as well. I hope they work. This is the actual title of my presentation. It was a bit too long to put it on the title slide, so I went a little bit shorter. Essentially, it's about the question how to protect fundamental rights when you do what Google does. Everyone in the room will agree that fundamental and human rights are complex issues, thus it will not be possible to provide you with a complete mapping here. Instead, I thought that I will quickly talk about the framework we use at Google to protect fundamental rights of our users, but also of third persons that might be subjected to technologies, products that are ultimately powered by our own technologies. I will talk a bit about how we put that framework into practice and then show a few initiatives. Well, obviously, and this is why I'm here, AI is a really big bet for Google, and AI is already applied across quite a broad range of topics. The promises as well as the stakes are particularly high when it comes to the area of healthcare. What you see here is the abstract, or at least a part of an abstract of a research paper published by some of our researchers at the very beginning of this year about an AI system for breast cancer screening. And the study showed that our system actually surpassed human experts in breast cancer prediction. What does that mean? Well, it means that the AI system analyzed the screens more accurately than the human doctors. And in addition, using that technology also reduced the workload by as much as 88%. The second example I would like to talk about is also a very recent one. It's about hyper-local forecasting of rainfalls. What you see on the left is a conventional model. It's about forecasting the weather over the region of Seattle over the course of a day. The conventional model updates and forecasts every hour. During that latency that results, no new input data can be digested. In the middle, you see the actual weather. So this is what we're actually trying to predict. Computer scientists call this the so-called ground truth. And on the right, you see our model. If you compare it to the ground truth, you see it's very accurate. It updates and forecasts every 2 minutes and at a 10 times higher spatial resolution than the conventional model. So it's undoubtful that these technologies, and there are so many more in education, in transport, in controlling energy efficiency to help fight climate change, these can be extremely beneficial to society and can even help to save lives. Notwithstanding this, we are, of course, also aware of the fact that these technologies do have certain faculties that actually may entail ethical and legal effects. In fundamental rights terms spoken, quite a few come to mind. First of all, probably the right to non-discrimination, but also the right to health, life, obviously privacy and data protection, right to freedom of expression, you name them, essentially. And yes, it's true, companies like Google, we are so centerpiece in the information ecosystem that a corresponding responsibility cannot be denied. You see here a quote from our CEO that was in the Financial Times just this Monday. So this was the reason why in mid of 2018, we set ourselves a normative framework that essentially governs everything we do in the space. We refer to that framework as our Google AI principles. Might make sense to quickly read them together. So AI, according to us, should be socially beneficial, should avoid creating or reinforcing unfair bias, be built and tested for safety, be accountable to people, incorporate privacy design principles, uphold high standards of scientific excellence, and be made available for uses that accord with these principles. Obviously, these are not the only ones. There are over 70 of such frameworks already today. They all look quite alike, I would claim. In one area, though, ours are distinct very much from at least most of the others. That's when it comes to so-called red lines. These are applications we are committed to not pursue. In essence, that's weapon and mass surveillance systems, but also more broadly, things that contravene international law and human rights. So there you go. The principles are actually a strong commitment to respect the international human rights framework. Much more important than the mere principles on paper, though, is how we put that stuff into practice. And to that end, the principles are complemented by, and these are dozens now, like a set of very concrete recommendations and initiatives that address computer scientists, how they can turn ethical considerations into code. If you're interested, you find more under that link there, or just search for it using the search engine of your choice and trust. As one example here, this is facets. You will all be familiar these days, because the debate has already advanced quite a bit, that there might be issues with the dependencies between a model and the underlying training data. If there's historical bias residing in the training data, that can sneak into the model, that can turn to discriminatory outcomes. So what facets allows is to visualize the single data points in a data set, just plugging into the browser. So what you see here are all 16,000 something data points in a US census data set. What that thing actually does in detail is not so important. The thing that's really important here is that the data points are colored by certain features. The husbands in the data sets, for example, are colored in blue, while the wives are colored in purple. And leaving aside all the details, it's obvious at first sight that there are a lot more husbands in there than wives. And if you want your model to behave as accurately on the wives as on the husbands, well, you might want to look for a more diverse data set to train your model. So facets creates fairness through awareness. And we've also made this tool open source available on GitHub, like many others, by the way, as well. Model cards are another concept that fall into that area of fairness and transparency. It's the idea to attach a documentation to a model that explains what the model actually does, what it was trained on, and most importantly, whether there are limitations, whether it acts or behaves differently on certain groups. So that helps you when you plan to use that to consider whether this is really the right model for you or not. And finally, since this is a data protection event, federated learning is a way to train a model without actually having to share personal information with the cloud. So all the training data, the training of the model happens on the device. We use that, for example, on Gboard. These are the keyboards on your Android phones if you happen to use one. So no word that you type in there is actually shared with Google. Just the update to the model is shared, where it's aggregated together with the updates of the other users, and the derived master update, so to say, is then rolled out to other users so that everyone can benefit from the improvements that others contributed. Abiding by these principles is governed by a multi-tiered framework with so-called Advanced Technology Review Council at the very top of the company that ultimately decides about very contentious or the most contentious topics in the company. As mentioned, the human or the commitment to human rights compliance is part of the AI principles, and thus also baked into the so-called principles review. These reviews are conducted by central teams that are supported by hundreds of experts across the company in the area of, for example, machine learning fairness, more broadly, human rights experts or teams, also data protection experts. We look at scale, we look at severity, but also at probability of benefits and harms. It's an iterative process that goes forth and back until we are satisfied that we are in a good place. Sometimes it happens that we ask product teams to modify their projects a little bit. In some cases, we also commission independent human rights impact assessments. In some of these cases, we also made public. Ultimately, and most importantly, though, we want the principles to become a part of the corporate culture. To that end, already thousands of our engineers have completed trainings in machine learning fairness. There were lots of in-person trainings to all the executives, and just recently we also rolled out our course, Tech Ethics in Practice, as a self-study course available to every employee. And I hope that I'm in time and we still have some
You are in time, yes,
minutes for discussion.
Thank you, Dan, and thank you all the panelists. Now, we have still 25 minutes for questions, if I'm not mistaken. Take the chance to come in the discussion. I think all the experts and all the speakers, they will open up. Yes, let's start here.
Hi, so I'm Barbara Eckel, an independent data protection expert. Microphone.
The microphone, if you can use the mic, Barbara, sorry. It's just behind you. It will be for the benefit of the other.
I picked up one very interesting remark in Eva's presentation about the de-responsibilization of children and parents, basically of data subjects, right? So my question would be, doesn't that totally fly against the spirit of the GDPR that was actually trying to empower data subjects? Isn't this basically a declaration of bankruptcy where we recognize that all this empowerment of data subjects doesn't really help them that much, because faced with AI and all the developments that we are currently observing, empowering data subjects just didn't get us to where we wanted to get? Thank you.
You can take it, you can take it.
Thank you very much for your question. I kind of had expected it. I didn't have enough time to go into it at the end, but I think there are two things. I think the argument that I want to make is valid especially for children. I think children are still somewhat of a different group than any individual. So I think, especially with respect to children, the expectations with regard to understanding information that is provided to them or exercising rights that are attributed to them in the GDPR might not be a sufficient level of protection. And I think sufficient is a key word. I don't think the argument is rights are not important, information is not important. I think it is crucial, it is essential, but it might not be enough. Yeah. And it might not be enough, especially with respect to children and parents that have to make very difficult decisions sometimes about allowing a child to use a service. They often don't know the service, they are not familiar with what it does, how children use them. Children are confronted with age limits that they need to respect, but all the kids in the class have the app, they want the app, they kind of know that they are not allowed if they are under 13, but they know very well how to circumvent these systems. If parents want to help them, they actually need to cooperate with the kids to lie about the age. So I think parents have a really difficult job in guiding their child. And so when it comes to processing data of children, I think some of the responsibility is simply too heavy. So I think rights are important, information is important. We need to think about how to make information child-friendly, so that the information is there for them to understand, but it might not be enough. I don't think it's bankruptcy. I think it's just rethinking certain things and coming to terms with the fact that when it comes to children, we might need to do something more.
I think this is really important. We just move from data management to responsible use of the data. This is part of the controllership. You know, controller nowadays, they do think with data in order to predict the future. We have seen many examples, but they're also acting with the data when they come into the embedded AI systems, because they simply take a decision on your behalf. And this is what's happening with automated decision. And of course, you can understand, if you are a data controller, the responsibility curve on you, it's evolving. You know, you're not any longer in a stewardship role, but you move it more to a fiduciary role. You need to build up a trustful systems, because this is very important. We have still time for a couple of questions. Yes, if you can take the mic. Let's collect 2 questions and then we answer. Otherwise, we have no time.
Okay, my question would be for Daniel, but it also brings Maja into the discussion to some extent. So you good, appreciated very much your talk and the commitment of Google to human rights and social good. But for instance, what about political advertising? Allowing targeted political advertising, is it for the social good or not? How do you assess that? And what about, for instance, I don't know, price discrimination? Is it for the social good? Face recognition. So I would like to have some idea of how you handle this kind of issues where different interests are involved.
Maybe I start with the political ads, because also Maja had raised the question to me as she started with her presentation. So first of all, let me make clear that Google never allowed like this granular micro-targeting. That was never the case with us. The only thing you can do, and this is really the deepest level, is gender, age, and some general location, which is basically the postal code level. All these ads, and I'm not really talking only about political campaigns now, are subject to a very broad set of policies. There's a super huge body of advertising policies, and there are many people working on compliance here. And we've invested a hell lot of money and lots of resources to make sure that our ads are relevant. First of all, we also need to say that most of them are not personalized at all, because they're simply search ads. So that the strongest signal that actually triggers an ad that you see on search is the keyword. So if someone Googles for a political candidate, that might trigger this, but has absolutely nothing to do with the personal preferences of that person. Further, you can also disable personalized ads very easily in your dashboard. I think just last year we removed 2.3 billion ads that were misleading or against our policies. We disabled more than 1 million of advertising accounts. And if we come to political advertising, we really raised the bar, not that much about the micro-targeting part, but rather the one about transparency. So if you want to place ads for a political campaign, you need to register in our systems, and you need to be very transparent who you are. You need to provide a purpose, and every user can search for a transparency report, political ads, and find at the level of each advertiser or political party what ad they showed and how many people saw that and what they paid for. So this is essentially what we did about political ads. And I mean, it's not really up to me to talk about the social benefit of political ads, but I mean, this is not new to the online environment. I would say like information building definitely does make sense in a...
Yeah, we don't have really a lot of time. Just one last question, if it's possible, because the time is already there, unless we can stay. The coffee break is there. But okay, there is one lady behind.
Yes.
Yeah, and then perhaps you can join to the lady if it's very short, okay? You can go already to the mic because then it will be, otherwise we don't have time.
Okay, so my name is Adriana. I'm a guest lecturer at Technical University in Eindhoven. I have one comment with regard to political micro-targeting for political purposes, because the thing I didn't hear in the presentation is that from my perspective, political debate is about hearing various opinions. So I think targeting one particular person is taking us away from an open public debate to conform an opinion on what you want to vote for. And I think from that perspective, if we look at political targeted advertising targeted micro-targeting for political purposes, we should not allow that, because if you target it at one individual, you don't have the open debate, which people need to be able to form an opinion what government they want. So the other thing is about the AI principles from Google, and obviously I think it's laudable, as a company to have this type of internal thinking and to put it at the center of your AI development. I see a similar movement with Microsoft, and I think I would hope that although this is something which needs to happen, that on top of that we will see regulation. And I know in the US this is very unlikely because it seems to be stifling technology innovation. But I think at a European level, because who is going to check you, Google, that your principles are the right ones and that you made the right assessments? And obviously taking as a point of departure that people, that you're doing the good. But we've seen also with Facebook, they not necessarily do. They think what's good, but not necessarily it's reflecting a European opinion or a different national opinion or whatever. So I think we need an extra regulatory framework on top of that to kind of assess and have opportunities to make sure that the right decisions have been made. Thank you.
Good, thank you. Before we come, let's take the question, because otherwise I give it the space and then we can just finish. Please,
okay, this will be very short. Matthew Newman.
Very short, very brief.
I'm a reporter at MLEX here in Brussels. Question for Maja, and it's about proposed regulation of political ads. In the last couple of years, we've seen a move from kind of general political interference by foreign countries into more hybrid attacks, like using chat groups. And I was wondering if you've done any research on that and what kind of response the European authorities could have for that kind of technology.
Good, thank you. Maja, are you willing to?
Yes, gladly, and I will try to be brief.
Very brief,
so for the first question, thank you very much for raising that. This is actually something I didn't have time to elaborate on, but what you raise is really part of the question of the freedom of information of voters that they get and freedom of expression in a way they participate in the political campaign. I do not think that political ads automatically stifle the debate, because the debate can also happen as a consequence of targeted advertisement, and it can also take place in the social media environment as a response to that, and even as a response from somebody who has perhaps been informed about other aspects of the political campaign. So, I think my bottom line is that we need more data of what kind of effects this advertisement actually has on people, and this data we do not have currently. And I think we should have a nuanced approach and really balance between different fundamental rights here. So we shouldn't jump into one regulatory solution, but have much more research. And then just on the second point, I think what you raise is quite important from a constitutional perspective on the question of horizontal application of fundamental rights, because we do not have a lot of secondary legislation which would apply directly to those specific groups, especially if they're in third countries. This is an extraterritorial question. So, we should see whether this actually falls within the scope of application of fundamental rights, but we can discuss more during the break. Thank you very much.
Good. I think you are right to have the last
don't want to have the last word, but just one sentence and very short about the regulation point that has been raised. In that Financial Times piece that I cited, Sunda also said, and it was picked up probably by every major news outlet here, also in Europe, that there's no question that AI needs to be regulated. The question is just how we do it. We need, of course, to lower the risks, but we need also to make sure that innovation is not hindered. And the worst thing we could do is to not harness the benefits of these technologies.
Yeah, good. I think we can close here. Thank you very much for your attention. As we have a stand at the center. Our center has a stand into the hall where there is the food corner. If you want to join us for continued discussion, Maja will be there, Mia will be there. It can be nice to meet you there. Thank you very much.